Hey patent friends, welcome back to another video. Coming to you today from Puerto Vallarta, Mexico. I'm on vacation and working remotely a bit. And I want to talk to you about why the patent process takes so long. I think it's really surprising for a lot of people that it can take years to go through the patent examination process. At the same time, it's not always a bad thing. So stick around to the very end. I'm going to give you some information about how to maybe speed things up if need be, but actually, how it can be good to delay the process. So stick around, we are starting right now. So for those of you who are new here, my name is Dylan Adams. I'm a patent attorney who represents clients of all sizes, whether it be garage inventors to startups to Shark Tank companies to Fortune 100 companies. I'm also the author of the best-selling book Patents Demystified, which is an insider's guide to protecting ideas and inventions used by inventors, entrepreneurs, and startups worldwide, including at top universities like Harvard, Stanford, and MIT. You might also recognize me from my appearance on CNBC as well. So this channel is all about giving you the insider information about patents and how to be successful with them. So be sure to subscribe and hit that little bell icon so you don't miss any important videos. All right, let's go ahead and get right into it. So to understand why the patent process takes so long, let's kind of just break down what the patent application process is. So there's two ways to start the process. One is by filing what is called a non-provisional patent application. And this is sort of the one that you typically think of. It's a really formal application, has to have very formal drawings, has to have a very formal description. And you file that at the United States Patent and Trademark Office, and then it can be 1 to 3 years before the examination process begins. So at that point, a negotiation begins with you and the examiner, and that can take several years as well. Okay, so that's with starting with a non-provisional patent application. But the typical thing that people do, they actually delay the process by another year by filing what is called a provisional patent application first. So the provisional patent application is just a placeholder. It lasts for 1 year, gives you patent pending status just like a non-provisional application does, but it expires the end of 1 year. There's no formal examination with the provisional, but it gets you that early filing date. It expires the end of the year, and then you have to file that non-provisional patent application. So with the non-provisional application, like I said, you go through all this examination. Hopefully the application is allowed finally. You pay an issue fee, and then the application issues as a patent. So why does this process take so long? Let's start from the beginning. So drafting a patent application, it's not just filling out some simple forms. Patent applications, if done correctly, they can be tens, if not upwards of 100 pages or so of really technical description of what an invention is, and that takes a lot of time to draft. Even if you're doing a provisional application, which a lot of times what I suggest is having the inventors, having them draft a detailed invention disclosure, that can take weeks, if not sometimes months, for people to put together the right description and really do it right. So even in the beginning, before you file your patent application, that can take a long time, and that's even if you're doing a provisional patent application. So you file the provisional patent application, and then it's a year before then you start filing the non-provisional patent application. So there's a year there. You file that non-provisional patent application, and again, like I said, it can be 1 to 3 years before the examination process even begins. That's when the patent examiner picks it up. You're just waiting in line, right? It's the government. The government is absurdly slow. So you're waiting in line, and then finally the examiner is going to pick it up, comes to the top of the pile that they have of applications to be examined, and they're going to do a prior art search. And they're going to draft what's called an office action that has rejections of your application. And keep in mind, rejections are a natural part of the process. I would say in 98% of cases you're going to have rejections, but it's not a bad thing. I always say it's like, think of it like any negotiation, like in Pawn Stars or American Pickers, or if you're haggling over prices for something, it's a natural part of it, right? So that's how you get a good deal, is through that negotiation. And patents are the same way. The way that you get the best, the broadest patent is through this negotiation process. Okay, so you get this office action with the rejections, and then it sets a timeline of 3 months to file a response to that office action without paying additional fees. And if you want to pay some additional extension fees, you can then reply up to 6 months later. So just from getting an initial office action to then filing a response, that can be upwards of 3 to 6 months. And a lot of times attorneys are backed up, it takes them a long time, and realistically, it ends up being at least 3 months, if not, closer to, maybe 4 or 5 months later. So you file your first response to that office action, and then the examiner is just going to sit on it, right? You go back in line. Sometimes it's really quick. Sometimes, maybe they'll get back to you in a few weeks, but realistically, it's probably going to be several months. And I've even seen office actions sit around for years. It's been like over maybe a year and a half that it takes the examiner to get back to you. So that's just one round, okay? So the examiner then, your response comes to the top of their queue, and then they have to do another prior art search. They have to form new rejections, review what your arguments and your amendments are, all that kind of stuff, and then they're going to provide you with a new office action, okay? And then again, the process starts all over. So you have another 3 months to respond, which could be extended to 6. And so this process, a lot of times, you could go back and forth indefinitely, theoretically, if you keep on paying fees and things and keep on doing responses, and it can take years. I would say the average is probably maybe 2 to 3 rounds of this, but I've seen times where, it's been 8 or so rounds and it takes years and years and years. Okay, so hopefully this negotiation goes well. The examiner then will say, okay, what you have, it's new and non-obvious. Over the prior art, you've met all the other criteria, and then the examiner will mail a notice of allowance. And again, it sets a long timeline. So then it's going to be another 3 months before you have to pay an issue fee. You pay the issue fee, and then it's going to be another several weeks, if not months, before the application then grants as a patent. So that's the reason why it takes so long for the patent process. But it's not necessarily a bad thing. There are some things where you actually want to delay. Delay is great. At the same time, there are other times where you want to try to expedite the process as much as possible, and that's what I'm going to talk about next. So you're probably asking yourself, how is it possible that it could be positive that the patent process takes so long and delay is good? How is that possible? A lot of people think, hey, I want to get my patent as soon as possible. That's the best thing that can happen. But counterintuitively, that's really not the case. My clients who are the most successful, they're the ones who take their time with the patent application process. So the biggest thing is to delay and defer cost. Patent applications are really, really expensive. The examination process is really, really expensive. Okay, so the longer you can delay those costs, the better. So that's why, people say, well, I want to start with the non-provisional patent application. That means, I get to, jump ahead a year instead of filing the provisional. But you don't want to spend all the money on the non-provisional patent application. Okay, start with the provisional patent application, which is a lot cheaper. It gives you a lot more options during that year when it's pending. You can add things to the application, and you just aren't outlaying as much money, and so you have a lot less risk. Then hopefully you'll get more traction with investors or with sales, things like that. At the end of the year, then you know that you want to spend all that money on the non-provisional application. You know that money is justified, okay? And then people say too, well, okay, aren't there ways that you could expedite the process and you can pay some extra fees and get your patent application examined sooner? Sure, there are ways to do that. You have to spend a ton of money in terms of extra fees. You also have to do a bunch of prior art searching and a bunch of analysis. So the cost of drafting that application is substantially more than doing a normal non-provisional application, which is really expensive as well. So you don't actually want to do this expediting of the non-provisional application. You just want to do the regular process where you file it and it waits in line for 1 to 3 years before examination begins. Because again, examination, there's going to be a lot of costs associated with that. Like every time you have to go back and forth with the examiner, your attorney's going to have to do an analysis of the office action, look at the prior art, and prepare a response. And that is really expensive. So you want to delay those costs as much as possible. So the next thing you're probably going to ask is, Dylan, well, I need to have an issued patent so I can sell my product, or so I can license it, or so I can sell my company, things like that. Totally untrue. And that's another thing that I see that people make a mistake a lot of times, is say, well, I'm going to wait until my patent application issues to start selling my product. Absolutely not. You should be ready to sell your product immediately after you file your patent application. It's fine if you're patent pending to sell your product. And a patent is not required to sell a product. Actually, patents are negative rights. They give you the right to exclude people from doing things, right? So excluding from making, using, selling, offering to sell, importing the patented product within the United States. It doesn't give you the right to actually do something. And the example I always give is, say, with pharmaceuticals. So you could get a patent on treating somebody with a drug for cancer, but that doesn't give you the right to do that. right? So you would actually have to get FDA approval in order to be able to use the drug for that. So always keep that in mind. Patents are negative rights. But what about things like selling your business or licensing the product? Again, absolutely not. You can have a pending patent application, and I would say a lot of my clients get substantial traction, and sometimes will make exits, as in like selling the company or being acquired by a company. That will happen while their patent applications are pending, even when they have pending provisional patent applications. You don't even need to be at the non-provisional stage in order to be able to sell your company or license or even sell the assets. You can sell a pending provisional application, you can sell a pending non-provisional application. And strangely enough, I would say that my most successful clients, the people who tend to be successful, they're the people who sell or get traction, get investors well before their patents issue. So in some ways, it can be kind of a red flag if patents issue sooner. And then so the next question you're probably gonna ask is, well, I need to stop other people from using my product. I need to be able to stop others and enforce my patent. So I need to get my patent as soon as possible. And again, that's not really how things work out. Enforcing a patent is really expensive, it's really difficult, and so a lot of times it makes more sense to delay the process and not get your patent issued as soon, because you need to build up a big bankroll, or maybe be acquired by a big company or get big partnerships that are going to allow you to actually enforce your patent. Because it's really difficult. I mean, you're looking at typically hundreds of thousands of dollars, if not millions of dollars, to enforce patents. And a lot of times you don't necessarily need even an issued patent to be able to enforce it. Sure, you can't sue somebody in court, but you can send them letters and say, hey, we have this pending patent application, we just want to let you know about it. And that can scare people off. Even just saying that you're patent pending, even just having people know that you have a pending application that's published. A lot of times, honestly, people don't even know the difference between a published patent application and an issued patent. They sort of see it as the same thing. So they're really, they're gonna see it as equivalent, that, you have a patent whether you actually don't or not. So by and large, delaying the patent process is actually a really positive thing, but there are some times when it actually helps and improves the business to be able to move things along, okay? So in general, it's fine to take a long time, file a provisional, take a year, file the non-provisional, and let examination begin when it begins. It's fine if it takes 1 to 3 years for it to begin. But once the examination process begins, it's typically better to try to wrap that up as soon as possible. And a lot of that is going to be optics related to investors. Because even though the examination process, typically, there's going to be a lot of back and forth. Like I said, it can be, sometimes 2 or 3 times, if not more, that you're going to go back and forth with a patent examiner. That's a natural part of the process. But investors and other outside parties, that kind of freaks them out. So a lot of times the optics are a lot better if you wrap up the patent process as soon as possible once it begins. And I've got some good videos about that, about how to get unstuck in the patent process, how to expedite things. So it's sort of out of the scope of this, but that's the time when you actually want to try to move things along, is once the application process begins. Because otherwise people start to think, well, oh, you've gotten rejected a few times, maybe it's not going to be allowed, or maybe there's something wrong with your product or your patent application and it's never going to go through. Again, totally not the case. It's a natural part of any negotiation to go back and forth with the examiner. Totally fine. But again, it's the investors who that kind of freaks them out. Okay, so that's one of the times where it's good to expedite things. Then the rest of the process, so as far as once you get a notice of allowance, if anything, the narrative on that is that your application is pretty much, issued already, and so then you don't need to, you don't need to expedite things. It's fine, take a few months to pay the issue fee and wait, and take the time to wait for the application issue. That's totally fine. It's only during the examination process where you're doing the office action responses, that's where it can be good to speed things up. So if you got some value out of this video, please give it a thumbs up and consider subscribing to the channel if you want more information on insider stuff about patents, about startups, and about how to succeed with your invention idea. And be sure to hit that little bell icon so you don't miss any important videos. Also, check out this video right here. This one's really good. It's about how to protect your invention idea. And then this one as well. This is kind of more detail about the best strategy for the patent process. So thanks again for watching, really appreciate it, and we'll see you again in the next video.